I don't know. When you say the city, no, sorry, but the city, you mean San Francisco. No, I don't. Thank you for coming again today. She lives in San Francisco. Just want to welcome you today. Thank you for attending the annual STLR Symposium. Sorry for the delay, although we are in the law review, we have technical difficulties, so apologize for that. But we'll probably run about 5 minutes late on this panel. We will aim to have our next panel start, let's say, 3:20, so we keep things reasonably on time. And then we also invite you to stay for an hour-long cocktail reception. I'm sorry, not cocktail, wine and cheese reception, which will be in the beautiful new law school building, the Newcomb building, right over there, from 5 to 6 tonight. You can avoid a little traffic that way and continue the discussion that these panels will spark today. So thank you.
Okay. Thanks, Holly. You stole my joke. I want to make a joke about it. I haven't been to a technology conference. I didn't have technology problems in 4 or 5 years of doing. So, my name is Ryan Calo. I work for the Stanford Center for Internet and Society. My role here is very minimal. I'm just going to introduce our panel and maybe try to foster a little bit of dialogue. But basically, the presentation is going to be Marvin talking about his work, and then comments from Professors Benkler and BeVier. So let me start right off and say that Marvin Ammori is a friend of mine and an affiliate of the Center for Internet and Society. He has worn a number of hats, including being one of the most prominent, if not at the time the most prominent proponent for net neutrality, and deeply invested in those debates in DC. And in fact, now he's been doing a lot of interesting work around copyright with the SOPA and PIPA legislative action that you've seen. He also was a professor at the Nebraska School of Law, and right now is a fellow at the New America's Open Technology Initiative, and also an attorney in private practice. He's written a very exciting law review article about First Amendment architecture that just this week is the subject not only of this panel today, but also of a online symposium at Concurring Opinions, which you should check out if you're inclined, where lots of very interesting people, Brett Frischman and others, are commenting on this work. To comment on, Marvin, you're punching a little bit out of your weight class here, I gotta be honest with you. To comment on this paper, we have 2 of the most preeminent First Amendment scholars, particularly with a focus on instances in technology. We have Yochai Benkler, who is a faculty member and professor at Harvard Law School, and one of the faculty co-directors of our sister center, the Center for Internet and Society at Berkman. Obviously, you know his work. Most prominently, perhaps, the wealth of networks, but many other publications in this area. And I think he's going to give something of maybe the pro side of it. I'm not sure, but he's going to be commenting on it. Maybe not. Commenting on Marvin's article. And then we have from the University of Virginia Law School, Professor Lillian BeVier, also a renowned scholar in the First Amendment area, who's also going to be commenting on this work. And so, if you don't want to hear anything more from me, I'm going to turn it over to Marvin to present. And then we'll get some comments and open up discussion. But thank you very much for coming.
Thank you, Ryan. And I do hope one of you will defend me a little bit. So here's my argument in brief. And I wrote it out because I was a law professor, and to force me to speak for only 20 minutes. See if I can do that. So here's my argument in brief. First Amendment doctrine embodies principles that empower government or that require government to ensure Americans have access to spaces to speak. This includes access to speech spaces on publicly owned property and on privately owned property, and both physical spaces and virtual spaces like digital forums. And I argue that these principles embodied in doctrine are substantive, and they reflect notions of an open, inclusive speech environment, and that these principles, while overlooked, should inform us about what the First Amendment means and should mean in the 21st century. So I will speak in 4 parts, as I always do, and each part is about 500 words. The first part presents the example of a concrete legal question, which is net neutrality. The second discusses how our conventional normative framework would address that concrete question. The third provides evidence of a different normative framework rooted in overlooked principles in our free speech tradition. And the fourth argues that those principles are worth defending and extending. So first, the concrete controversy. In December of 2010, after almost 10 years of debate and litigation, the FCC adopted network neutrality rules. Those rules are now on appeal, and network neutrality refers to a law that would keep the internet open by forbidding phone and cable companies from discriminating in favor or against certain sites. So during the years of debate and on appeal, defenders and critics would invoke First Amendment arguments. Those in favor of net neutrality, including me and many others, called it the Internet's First Amendment, or some refer to it as the First Amendment issue of our time. And in 1996, the Supreme Court characterized the Internet as, quote, a unique medium known to its users as cyberspace, located in no particular geographic location, but available to anyone, anywhere in the world. Net neutrality would preserve open access to those digital speech spaces. It would preserve history's greatest engine of free expression and political deliberation, the internet that has shaped our elections, fostered an Arab Spring, and has done so much more. Those opposed to net neutrality in the United States had a different view. They argued that adopting network neutrality laws would in fact violate the First Amendment. They argued that phone and cable companies transmit speech, government should not be involved in regulating speech, and network neutrality is government regulation. In fact, to them, network neutrality was especially dangerous because it was government regulation of these core vital speech forms for the 21st century. So network neutrality can be our example for the talk. So part 2, in analyzing a concrete problem, I'm going to rely on 2 words that law professors use, descriptive and normative. And we need both of these words to preserve free speech in the 21st century. So first, descriptive. Descriptive analysis is analysis of what the law is, and normative analysis is analysis of what the law ought to be. And when we engage in normative analysis, we often apply a norm or a metric. And those of you who've gone to law school know that law and economics will often apply a norm of efficiency or low prices. And then you'd evaluate a law based on that norm. For normative analysis of freedom of speech, we often don't use efficiency, we use other norms. We could use really general norms like promoting democracy, promoting individual autonomy, but often we use sort of more mid-level norms that are easier to administer, that aren't as high level. And we derive those norms from our understanding of what we think our First Amendment tradition has been. And so First Amendment scholars will often look to venerable or bedrock First Amendment principles as norms, and they conclude from our tradition, looking at our tradition, that those norms generally want the government to stay out of speech. And if you look at some of the most famous canonical cases that we read in law school, those involving offensive speakers, flag burners, racists, pornographers. Generally, the right answer is keep government out of speech. The First Amendment embodies a freedom from government interference in speech, embodies a negative liberty, and that's the key principle by which we should measure whether a case is rightly decided, whether a law would be constitutional. So at the same time, there have been other scholars who put forth a more affirmative vision of what the First Amendment should require, the kinds of encouraging both courts and Congress to affirmatively promote free speech rights. And some of those scholars are really well-known scholars: Cass Sunstein, Ed Baker, Olympus, Jack Wilkin, Yochai, Benkler. And often, you'll note that government is often involved in speech, often involved, especially when it comes to media regulation, communications regulation. There's an entire Communications Act full of rules that govern speech environment. But often, when these arguments are raised, the conventional view is that negative liberty is the norm, and that all of these other cases are just minor exceptions. There's an exception for media, there's an exception for broadcast, and that these exceptions tell us little about what the First Amendment means or what norms we should apply in evaluating freedom of speech going forward. And if negative liberty is our norm, and if it's the norm for new technologies in the 21st century, that would tie the government's hands from doing a lot of good in shaping new technologies that connect us all. It would disempower the U.S. government and the citizens that are involved in campaigns, people who are involved in fighting SOFA, fighting for net neutrality. They wouldn't be able to change the law because whatever law they would change would be unconstitutional, because government shouldn't be passing laws affecting speech. And so beyond net neutrality, there's a whole range of laws that would actually affect freedom of speech that would be unconstitutional. One example is a few years ago, there was a pro-choice organization that wanted to deliver text messages to all of its users, and Verizon refused to furnish the text messages, saying that it had a policy against controversial messages, and when someone wrote a petition trying to get the FCC to look into that matter, that someone being me, the response from Verizon was, it violated our First Amendment rights to force us to carry messages we don't agree with. It would be like forcing us to hand out pamphlets, and the government should stay out of speech altogether. So the article I wrote attempts to address this challenge of sort of two different views of the First Amendment and how they might affect the future of speech in the 21st century. So the normative analysis that I mentioned in part 2, the one about negative liberty, keeping government out, that normative analysis rests, I think, on a descriptive claim that the First Amendment itself and that our entire tradition embodies a negative liberty and an idea that there's principles keeping government out of speech. That's what our First Amendment tradition represents. It's a descriptive claim about our tradition. And what I argue in the paper in here is that that's not the best way to understand our First Amendment tradition. Right? There are a lot of so-called exceptions to the tradition of negative liberty, far more than usually assumed, and they govern many of our most important speech forums. When we think about physical speech forums, digital speech forums, virtual forums, any way for people to communicate with one another, virtually or in person, a lot of those spaces are actually governed by, quote, exceptions to negative liberty. And that we should look at those exceptions and try to make sense of the principles and ask, what do they actually say about the First Amendment? And how can those norms govern what we do going forward in the 21st century? And so the point of in the paper I have a very long extended discussion of precedent, of tradition, of the principles underlying the tradition. And the point of that discussion isn't to say, I have descriptively explained what the First Amendment has done and I've made sense of it. It's just that these norms, these different principles that are not negative liberty, are very strong, very well supported, and they exist in the doctrine and can't simply be waved away. Right? And these norms essentially encourage the government, I think, to promote spaces for speech so people can communicate. And just a minor point, if you think about why does space matter for speech, think about Occupy Wall Street, think about Tahrir Square, think about public parks, where people this year have been commenting revolution. Think about digital spaces like Twitter, Facebook. Think of YouTube and the videos that went viral, that connected people, and that really spawned a lot of change in the world. So in the paper, in canvassing precedent, I identified 5 principles, and I'll briefly mention each one of them here. And the first principle, and I'll let you have the joy of reading about it on your own at the beach on a sunny day, or to wait for the motion picture of the 5 principles. So, first principle. Government is constitutionally required to ensure that any citizen has some minimal space to gather and speak. So even in a content-neutral way, government can't close streets or parks generally in any town with speakers. We can't do that in municipal towns. Even in cities that are owned by private companies, some the streets and parks are open to speech. And at one time, 2,000 towns across the country were owned by companies. And so the first principle, which focuses on the traditional public forum, requires government to do something. And the other principles are all discretionary. They all permit the government itself to adopt rules to open up spaces. Thus, government be involved in the speech environment to encourage avenues for more speech. So the second principle, very simply, is government may open additional spaces for speech beyond these minimal spaces. It may open digital spaces, say, through net neutrality. And so throughout history, we've seen that government can open privately owned spaces, such as passing laws to open up shopping malls for speech. You can open virtual spaces. And here there's a long line of cases and laws. The telegraph, the phone system. The phone system is central to speech in our society, not just because of political robocalls, but also because it's one way that people have communicated over the years. Government can designate additional public forums on its own property, amphitheaters, limited public forums for speakers like students. And so as a general rule, there's been a long host of rules that have opened up spaces, both physical and virtual, and both publicly owned and privately owned. The privately owned communications infrastructure is maybe the best example. Everything from cable to telephone to broadcast. So the third principle, very briefly, is that government can extend speech spaces to all speakers, universally, the universal principle. Fourth is that government may create forums for national and local discourse. And the fifth is that government may ensure that diverse sources are available through speech spaces, through access rules and ownership limits. And for an example of the last three, like universality, local forums, and diversity, you can just consider the phone network, which is a major speech medium. So in terms of universality, there's a complex universal service fund that taxes some speakers to subsidize other speakers. It taxes people in cities, so people in rural areas can get phone service. That whole subsidy scheme is being moved to the internet. It's separately structuring the architecture of our speech based on substantive goals and making sure everyone is connected to the internet or to the phone booth. It's not government staying out of speech at all. So that's one, universality. Two, local and national speech. There's always been price regulation for many years, ensuring that local calls were cheaper. I think on the assumption that local communities would be stronger. And then there's always been regulation of the phone sector to make sure all of us can use it. Phone companies can censor our calls or block our calls. And so none of these five principles reflect a mere negative liberty. All of them burden some speakers to benefit others. All of them have a substantive idea of promoting more speech through additional spaces, universal access to spaces, diversity, and sort of local and also national forums. So on to the last part, which is defending the principles that identify in the doctrine. So I argue that these five principles are normatively defensible. They're good. I like them. They're good. And so usually we evaluate mid-level principles like this, like universality, access to more spaces, you might appeal to higher level principles like democracy and autonomy. And there are lots of conceptions of democracy and autonomy, and I argue that under most conceptions, that a lot of conceptions that people support, these principles refer to their autonomy and democracy, like universal access, diverse sources. And also, you can judge these principles by asking, do they lead to good conclusions? Do we sort of agree with the outcomes? And one of the outcomes, for example, would be that laws such as net neutrality or other laws to shape the environment to promote access for all people, to ensure everyone has access to the internet, that these laws would be constitutional. In fact, I think courts should follow those principles even more aggressively going forward. So beyond a normative defense, I think there are some theoretical implications if we take these principles seriously. So, so the main thought here is that these principles, I think, suggest that government, and especially we, should be involved in shaping our speech environment going forward. Right? We often think that courts decide First Amendment law for us, they decide where we can speak, where we can't. The courts are the main expositors of our speech rights, but as it turns out, government has been deeply involved in shaping the spaces available for us to speak. And that might be a good thing, that might be a bad thing. I'd argue it's a good thing that we can be involved in shaping these media and be involved in these debates. So the main takeaway there is that tasking the legislature with the role to empower, the role empowers the public to be involved in this debate about our democracy. So that's really the overview of the argument. One, an example is net neutrality that I thought I set up. The second, the key problem is that existing doctrine relies on norms that are focused on a negative liberty that I think just isn't reflected in our tradition, and that our tradition actually supports a broader understanding of the legislative role and of the need to ensure spaces for all of us to speak in the 21st century. And that simply staying out of regulation of the internet or new digital media is actually a bad solution. What we need to do is figure out when can government be involved, when can't government be involved. And the principles like these, I think, will help guide us when we think about those questions. Thank you.
So I'm going to turn it over to Professor Benkler. I meant to say to both Professors Benkler and BeVier, thank you so much for coming all the way over here from Boston and from Charlottesville. I do have a couple of questions of clarification for Marvin, which I'll ask at the end. No. Well, I'll ask you one quick question of clarification that I just wanted to figure out, and then turn it over to the actual experts. So one thing I'm not understanding is, I thought you walked through very nicely how this question of economics might be, are courts deciding on efficiency reasons, is that what they're actually doing versus what they should be doing? And I think you actually answered that question here. You're saying that it's not just that courts do this, but actually that they should do it?
That's right.
Right. And so if that's right, so, but do you have any opinion as to whether courts know they're doing it? In other words, is it that there's basically like these cumulative exceptions that ended up being enormous, so that you think, gosh, it's so much speech is subject to these exceptions, and if you were to confront a judge or a justice, they would be like, wow, I didn't realize that? Or do you think it's something that they're doing, in a sense, on purpose, because they recognize that that's the right way to think about it? Just going to give you a view.
So, okay, so what this kind of reminds me of is there was a lot of literature about contract law and property law, sort of analyzing the common law and seeing that courts were accidentally stumbling in the same direction over and over. It turned out contract law was efficient, without judges totally always recognizing that's what they were doing.
Yeah.
There are some cases where the courts say, sort of overriding First Amendment interests that we support, that the First Amendment rests on the idea that we need the widest dissemination of speech from diverse and antagonistic sources. And that quote comes up over and over, but it's like dicta. It's not quite a principle. And so there are other tests, but it's sort of as though they wiggle around. They find an exception. They back into the solution. That's, I think, the right solution right out.
Okay. All right, well,
but there are competing norms and competing principles. So sometimes a principle that isn't as articulated might not.
Well, thanks very much. Okay, well, Professor Benkler, I'd love to turn it over to you for your thoughts.
So first of all, we'll see what happens technically, because I'm not using my usual system. I'm using your system, and we'll see if I can navigate it properly.
You have a different system. As I said, on my system it works, but that one's Linux, so sound anything from here? Okay, do you have sound here?
Yeah, right there.
You know this. It turns out that you need spaces to speak, and you need to be able to breathe. Speech depends on spaces, and people constrain speech by constraining spaces. But this speech occurred in two places. It occurred on the ground as the kids were being sprayed. And it occurred in the hands of every person standing there and communicating with the rest of the world that says, this is us here laying our bodies. And if you spend the 8.5 minutes, you eventually see this community of students shouting at the cops, this is our space, not your space. And eventually the cops, you're safe, leave. And they leave. But they speak to all of us and communicate with all of us as we move on. So where do we stand here again? The reason I'm doing it this way is because apparently there's not enough length of cable to let me connect with my usual system. So how do we do this now? Okay. So then we move to Occupy Wall Street itself, which, remember, New York City's parks were closed to them overnight. So they used this narrow exception of Zuccotti Park, which was a public-private or a private space that was nonetheless publicly open. And that's what allowed this piece of speech, one of the most significant protests in American recent memory, to change space, to occur. And again, central to the move was the capacity to record and speak yet again. And again, I'll try to figure this. I don't use it. You might even find out later on why. But now we're using all sorts of forms of speech to speak about this. So this is from the day of the removal itself. Now we're speaking by video to each other, but we're also speaking with a shared cultural space of understanding. Illegally, this is not fair use, the whole piece. This is how we speak to each other today. And a law that says that this is illegal is a law that restricts speech, no matter if you call it copyright or otherwise. And fundamentally, if we end up planting an American flag or an American idea, yeah, helmet and all, American First Amendment. But how do we communicate this to each other if not in this particular form? What are the spaces of the 21st century? And can we speak? If the only place to speak, as Marvin talks in his piece, is a mall, then you need to speak in a mall, because otherwise you're talking to four walls. If the only space that you can speak effectively to people is through their devices, because that's the space we occupy together, then that is the space we occupy together. Where are we? So Marvin talked about, what's our view all here? What does this generalize? So not a system I'm familiar with. Okay, you all manage. Marvin talked about this one. The Ed Bush's global gag rule against birth control that was blocked by Verizon that he wrote about. Again, where do you meet people? What is the form in which you communicate? One of the fascinating things is how the particular set of devices and networks do or don't permit openness. So if you look here in Occupy Oakland, you've got A, the live streaming, which is critical to building the connection, and B, the necessity of building your own network based on unlicensed spectrum, Wi-Fi, in order to be able to work around any constraints that others would be. You build your own network around it, but it becomes an integral part of the organization. Building your space for speech becomes an integral part of the framework, as compared to this platform that runs on proprietary infrastructure over a proprietary device with a proprietary operating system using digital restrictions management that can determine what does and doesn't run. So you can have this letter to this particular person who says, thank you for submitting news tunes to the App Store. We reviewed news tunes and determined that we cannot post this version of your iPhone application to the App Store because it contains content that ridicules public figures. And as long as the platform by which we communicate with each other is one that is governed by terms of service, and as long as we conceive as application of terms of service as just private law, not something that implicates the First Amendment, this is acceptable. This is acceptable. And then, of course, it's easy to translate that into blocking from the App Store this app. That is a game that exhibits the Foxconn suicides by workers on the production line of the iPhone, which again is blocked as an app. Because, needless to say, it's inconvenient for this device to tell the story of its own human misery in its production. Do we care about this? Well, the WikiLeaks app was pulled, although there was some jailbreaking that allowed it to come in. What this does is it opens up a space for a new public-private partnership in censorship, where government uses its influence over private parties to achieve constraint of speech. No ridicule of public figures wasn't done at the administration's request, but here we have, I call on any other company or organization that is hosting WikiLeaks to immediately terminate its relationship with them. WikiLeaks' illegal, outrageous, and reckless acts have compromised our national security and put lives at risk around the world. How many lives have we known now after a year and a half? Still no payment systems. Still hounded. What we're seeing is a universal use creation of spaces that are private spaces for speech that are absolutely necessary for communication that then become the subject of constraint by either private parties in defense of their own interests or by an unholy alliance between public actors who informally lean on private actors to use that doctrinal freedom from the First Amendment to shut down materials. And we've seen now with SOPA and PIPA the willingness of the government not only to have it in one context, but to generalize the approach of focusing on private parties and telling them to shut things down. Because they are inconvenient, but they cannot be directly shut down by them. This is the platform of political mobilization. This is the platform of political action. This is what the 21st century is. The press and the public sphere and public forum. This is where we are. We're not elsewhere. One of the things that Marvin does beautifully in this piece and earlier pieces is walk us through the sheer implausibility of saying a First Amendment law that really started to change in 1925 and is a creation of the 20th century is built around a core of pamphleteers and door-to-door knocking, and to some extent, later half of the century, press, but not telephone, not broadcast, not cable, not satellite. Those are all exceptions. What you're seeing is ideological insistence on excluding evidence to the contrary to be able to tell a coherent story that sees the government as the threat and refuses to see the threat as power, whether government or money. Whereas in fact, and what he does beautifully in this piece is walk us through how when you actually look at the doctrine as opposed to the ideology that tears off the doctrine to the side, throughout most of the platforms that influenced most of what we knew and how we came to know it, reality trumped ideology. Reality meant that courts said, well, broadcast is different. Cable is different. Telephone, well, that's different. Telegraph, that's different. Satellite, well, that's more like cable. But, pamphlets. So reality has a way of pushing its own way. But what we've seen is what my dear friend and colleague Jack Balkin called, about other areas of the law, ideological drift. Starting in the 19th century idea of freedom of contract drifting to becoming essentially from something that was about free labor and not indentured servitude to something that was about shutting down the progressive state. And that didn't break down because of a doctrinal change. It broke down because of the incoherence of that doctrine in the face of the New Deal, and ultimately an acceptance by a Supreme Court justice to just flip in the other way. In the same way that the difference from Bowers versus Hardwick to Lawrence versus Texas is fundamentally what is acceptable within polite, decent company to say about gay and lesbian human beings. And I think one of the things that happens to us now is that as the 21st century comes along and we come to see, where are the people? And we come to see what happens when a First Amendment that is fundamentally about protecting against the government. And we end up with Citizens United. After 25 years or 30 years from Buckley versus Valero, we end up with Citizens United. A First Amendment that protects the rights of money to speak, first and foremost. As the same First Amendment that allows the telephone companies to make an argument plausibly, not implausibly, plausibly, and win in a couple of courts of appeals over a decade ago, the claim that when they're common carriers for data and they're common carriers for text, if they happen to be carrying video, suddenly it's a First Amendment problem if they're told to also be partially common carriers for that. That's incoherent with the way in which the First Amendment really operates in the 21st century. And that incoherence, and the idea that the First Amendment has become a tool to prevent opening up the actual spaces in which we actually speak to each other, and supporting money rather than speech, is the incoherence that will ultimately force things to be turned around. And I don't know if it will happen tomorrow. And one of the nice things about what you've done in this piece is that you've provided a ladder for judges and justices to begin to climb down from what is palpably the wrong way to think about the First Amendment in the 21st century. Because the 21st century, the First Amendment is Linda from Las Vegas. Today it's 350,000 people who've looked at her video in her bathrobe, standing quietly in front of a camera and telling the Susan G. Komen Foundation what breast cancer is and what breast cancer isn't. For 4 minutes and 40 seconds, she tells about what it is to have cancer and what it isn't. What is left and right is not what it is. And any First Amendment standard that suggests that this is not first and foremost what the debate is about, where you can say, well, it's streaming media, I'm blocking that or I'm slowing that down. And that's a speech right for a company. But not this, is an unstable doctrine, and is a doctrine that will have to give way. And it will give way in part through people providing, as Marvin did, a path for judges to do it in a professionally acceptable way. But it'll give way in large part because it's incoherent with the way we speak with each other and participate as citizens.
Thank you very much, Professor Benkler. Next, we're going to hear from Professor BeVier, and I don't think you need the video, right? You're all set? Okay.
Well, I think my role here is the designated skunk at the garden party. We have to have one at every party, even though it kind of lightens things up. Professor Ammori's paper is ambitious, to say the least, and his effort is much to be admired for its creativity and for the boldness of his approach, and for the courage to say to the court and to the academy, when it comes to the First Amendment, we ought to just kind of scrap everything we thought we knew about it and start over. According to Professor Ammori, most conventional wisdom about the First Amendment is mistaken, especially that which conceives of the amendment as guaranteeing freedom from government. Instead of understanding it in significant ways, the amendment should be understood as an affirmative guarantee, and in particular as a guarantee of a sufficient space in which to speak. In his view, much of what the court has said about the First Amendment misconceives and unduly limits its purposes. Moreover, the court has permitted the government to undertake many legislative and regulatory initiatives, such as, not limited to, regulations ensuring access to phone lines and laws that establish and govern the Postal Service, which have hitherto unperceived affirmative First Amendment implications. Now, in offering his reinterpretation of the amendment, and in identifying and interpreting the court's role, as he puts it, in, quote, ensuring, requiring, or permitting government to make spaces available for speech, Professor Ammori proposes nothing less than First Amendment regime change. He recognizes that the implications of his model are fairly revolutionary, and that they implicate legislative constitutionalism, sufficiency, diversity, and goals beyond negative or affirmative liberty. No mere tinkering around the edges for him. Now, Professor Ammori knows that I wasn't brought here all the way from Virginia to heap nothing but praise on his article. Instead, my role is to offer a couple of points of disagreement, so I guess I should get started on that. In the short time I have, I can do justice neither to his paper nor to my disagreements with it, so I'll limit myself to offering just a couple of thoughts. First, though I admire the ambition of Professor Ammori's paper, I'm just very skeptical of scholarly efforts like his, which set out to reinterpret whole swaths of doctrine. I'm even more dubious when such efforts are coupled, as his is, with a call to modify in profoundly significant ways our understanding of what an entire domain of constitutional law is all about. Among the reasons for my skepticism about such wholesale efforts is the fact that even small changes in legal doctrine always have unintended consequences. And unfortunately, the unintended consequences all too often cause the costs of legal change to swamp the projected benefits. I think, for example, of the Red Lion case, which you disavowed, with the result there in Red Lion, which was to require broadcasters to permit free time for to respond to personal attacks. It was supposed to be that that was going to increase diversity of speech, and over the course of several years trying to implement that doctrine, it was found that instead of increasing the diversity, it damped actual debate. That was an unintended consequence of the Red Lion result. I'm dubious in spades about efforts like this when I think about Professor Ammori's proposal, because he writes as if tremendous gains and only trivial costs should be expected were his proposals to be adopted, and the respective roles of courts and legislatures revised accordingly so as to assure everyone a sufficiency of access to spaces for speech and to guarantee diversity of opinion. But it's just not possible to make changes on the scale that he proposes, even to an unsatisfactory status quo, without incurring significant costs. And Professor Ammori's paper would be considerably more persuasive, I think, if it acknowledged this fact. For one thing, the negative liberty model has profound normative appeal, not to everyone, but to many thoughtful people. And Professor Ammori should concede that abandoning or even significantly revise it will carry a price, and possibly a very high price. Instead, he represents the model, dismisses the model as representing little more than confusion of is with ought, and a mistaken view of is to boot. So now to my second point of disagreement, and I'm sure this is the one that you two will most disagree with. That is, but I regard it as the most disquieting, and that is the cavalier way in which Professor Ammori dismisses the claims of owners of private property. Like many First Amendment scholars, Professor Ammori exhibits an inclination to regard speech claims as presumptive trumps, to which all other claims, such as those of private property owners, more often than not ought to be subservient. He insists that the First Amendment obliges the judiciary to require that individuals have some basic adequate spaces for autonomy and public discourse, and also that it permits government to open additional spaces for speakers, whether those spaces are publicly or privately owned, this is his words, and whether for all or particular classes of speakers. Note how casually he lumps together laws for private and public property. Now, privately and publicly owned spaces are conventionally believed to be subject to very different legal regimes when it comes to enforced access for speech. But Professor Ammori maintains that the same principles often apply to both. The claim, I think, is descriptively inaccurate because it misreads a lot of the cases. In addition, it's normatively problematic because it rests on a myopic view of the role of and value served by private property rights in our legal system, about which more in a minute. First, let me say something about the most glaring descriptive error that the analysis entails in my mind. Professor Ammori characterizes public forum doctrine as an outlier on account of its inconsistency with the view that the First Amendment secures merely negative rights. And he's right about that. I think public forum doctrine does affirmatively require government to permit speech access to publicly owned spaces that have, time out of mind, been open to speech uses. That is, traditional public forums. But insofar as the court's reasoning is concerned, the assertion that the doctrine stands for the proposition that some minimal spaces ample for some speech purposes must be available is at best an over-reading of its implications, or at least of what the court consciously set out to do. The affirmative right the traditional public forum doctrine recognizes is less a function of the court having purposely vindicated the principle that some minimal spaces ample for speech purposes must be available than it is a function of the fact that the public always has been permitted to make speech use of streets, sidewalks, and parks, and thus long ago the public acquired what amounts to a speech easement in them. Professor Ammori, in my view, compounds his over-reading of public forum doctrine when he asserts that the principle he claims to derive from it, quote, is not limited to publicly owned property, citing the 1946 case of Marsh versus Alabama, in which the court overturned the trespass conviction of a woman who had been handing out leaflets on the streets of a privately owned company town. As Professor Ammori acknowledges, Marsh is an outlier. But he claims it is an outlier, quote, in the same way, close quote, as is the right of access to publicly owned streets and parks. He thinks it demonstrates what he refers to as a broader point about speech spaces, namely that in any town, private or public, streets and parks must be available to speakers. I think this is wrong, particularly in its implications. Yes, the right of access to publicly owned streets and parks has been many times affirmed, but Marsh stands quite alone. True, it hasn't been explicitly overruled, but it has no progeny. Indeed, the court at one time flirted with the possibility of applying a Marsh-like principle to privately owned shopping centers, and it withdrew from that and decided and noted in, for example, 1972, that it had never held that a trespasser or an uninvited guest may exercise general rights of free speech on property privately owned, and it has never deviated from this position. Now, many scholars wish Marsh were a paradigm case. And if it were, of course, it might buttress Professor Ammori's assertion that because, quote, deliberative spaces support democratic debate and further the autonomy of speakers and listeners, the benefit of requiring private owners to make their property available for speech uses should be seen to outweigh the potential autonomy burden on them, on the speakers. But the upshot of the Supreme Court's post-Marsh decisions is decidedly to the contrary. The property rights of owners have been uniformly vindicated, and it's been quite clear that enforcement of state trespass laws at the behest of private property owners who wish to exclude persons who want to engage in expressive activity on the owner's property does not violate the First Amendment. Property rights, not First Amendment rights, are trumps. I know this is anathema in a First Amendment symposium, but I said it anyway, and I'm not sorry. And even when access speakers could not constitutionally be excluded from otherwise similar but publicly owned property, state law may permit a private owner to enlist the aid of the court to exclude it. Professor Ammori might probably would offer the rejoinder that in his world, legislatures are and should be equal partners with courts in vindicating the public's First Amendment rights to a sufficiency of speech spaces, and legislatures may require private owners to permit access to their property for speech. Indeed, in several cases, access seekers have invoked one or another statutory or regulatory scheme that purported to grant them access to the property of others. In these cases, of those that are conventionally considered to be First Amendment cases, the court has analyzed claims of compelled access for speech by asking whether being required to grant access violated the property owner's First Amendment rights rather than the property owner's the owner's property rights. And this, I take it, is net neutrality. First Amendment rights that are thought to be at stake. The cases in this category are somewhat evenly divided between those sustaining the compelled access claim and those sustaining the property owner's First Amendment challenge to it. Still, the facts as well as the rhetoric and tone of two of the most significant opinions sustaining compelled access, namely Red Lion, with which Professor Ammori disagrees, and Pruneyard, suggest that the court regarded them as presenting exceptional circumstances that require departures from mainstream First Amendment doctrine. And I take it that what Professor Ammori and Professor Benkler would say is that they aren't exceptional at all, and mainstream First Amendment doctrine always would have sustained those regulations. Only in Turner Broadcasting versus FCC did the court sustain compelled access using the customary First Amendment analytical tools that Professor Ammori would reject. In support of his claim that his 5 persistent judicial principles require or permit government to ensure spaces in the service of particular substantive speech goals, Professor Ammori more than once refers to what he alleges is the Supreme Court's basic tenet, and he did refer to it this afternoon, which in his words, though not quite the courts, or not always the courts, is that, quote, the widest possible dissemination of information serves the First Amendment. Well, I suggest that this way of putting things gets the matter backwards, because it seems to me that the court's basic tenet is not so much that wide dissemination serves the First Amendment as it is that the First Amendment, and in particular First Amendment freedom, serves wide dissemination. The First Amendment guarantees freedom, and with freedom comes wide dissemination. In other words, the purpose of the First Amendment is not to assure that the widest possible debate or dissemination of views takes place. To think that, in my view, is a mistake. It's to mistake, as Charles Fried once put it, the effect of the First Amendment principle for the principle itself. The First Amendment protects the liberty of expression, and it is an effect of this liberty that there is wide and uninhibited dissemination of information and discussion. That wide dissemination of information occurs when private citizens have liberty to speak should not be taken to imply that the Constitution directly guarantees that the widest possible dissemination must occur, or even that each citizen should have, in Professor Ammori's sufficient spaces for speech and access to appropriately diverse sources. I have other reasons for skepticism about Professor Ammori's argument with regard to compelled access to privately owned spaces. One very important one is that I can't discern either a constitutionally supplied metric for judging whether spaces for speech are sufficient. Why aren't they already sufficient? How much is enough anyway? And nor can I imagine that there exists judicially or even legislatively manageable standards for determining whether the required diversity obtains. Why doesn't the present cacophony indicate that we have enough diversity already? How many opinions do we need to have expressed? Moreover, disputes between access seekers and property owners are simply disputes between private individuals about how resources should be used. And in my view, the Constitution has very little to say, indeed almost nothing, about the substantive laws that resolve such private disputes, nor does it say anything about when private actors should not be permitted to invoke the aid of courts to enforce trespass laws. Indeed, to my mind, one of the underappreciated virtues of the neutral enforcement by the state of private property right to exclude is that it does not entail any risk of deliberate government discrimination among viewpoints. Trespass laws are indifferent as to the point of view both of the access seeker and of the owner. And enforcing them does not put judges or any other government official in a position to censor or punish particular speakers or to manipulate public debate by selectively denying speech opportunities to disfavored views or granting them to favored ones. The common law of property generally allocates decision-making authority about the use of resources to private owners, and it generally stands ready to enforce their decisions to exclude speech via the trespass laws, with no questions asked about the effect of the exclusion on the quantity or diversity of speech. Now, especially when it comes to intrinsically scarce tangible property, widespread agreement exists that in addition to preserving the autonomy of speakers, a system of private rights has significant utilitarian advantages. It prevents wasteful overuse of resources, it staves off the tragedy of the commons, and it encourages optimal investment, since both gains and losses come back to the owner. Now, Professor Ammori does not appear to agree that these utilitarian advantages of a system of private property rights obtain, or if he does agree that they do, he doesn't think they account for much. To the contrary, he argues, or seems to argue, that claims about access to privately owned speech resources, speech spaces in his words, should be constitutionalized, and that decisions about whether access for speech should be granted over a private owner's objection should be transferred from the private owner to the government, court, or legislature. He appears to believe that the only advantage the private property rights secure is that of preserving the autonomy of the owner, where he claims that, quote, because deliberative spaces support democratic debate and furthers the autonomy of speakers and listeners, the benefits of compelling access to them should be seen, in his view, to outweigh the potential autonomy burden on private owners. Now, presumably, Professor Ammori is convinced that private owners are systematically inclined to undervalue speech uses as compared to other uses of their property. Perhaps so, though he offers no real evidence that this is the case. And more importantly, he appears to believe that government decision makers are systematically not only completely trustworthy, but inclined and able to value speech uses of property in comparison to the relative value of other uses, neither too much nor too little, but just right. And he seems to think that government decision makers, once they're given the mandate to do so, the explicit mandate to do so, will be able to bring about states of the world in which there are enough spaces for speech uses as compared to spaces for other uses, and there will be just the right amount of diversity of viewpoints. I don't know the source of his confidence in government decision makers, nor does the paper provide reasons to share it or evidence to support it. My own observations of the way government actors, bureaucrats, legislators, judges, behave leads me to think that Professor Ammori's confidence in them is quite unjustified. But since his paper is premised on that confidence, I must either conclude that his premise fails, or ask him to tell us where these paragons of virtue and wisdom have been hiding. Thank you. And you don't have to laugh.
Great. So I think that in the interest of time, I know that I have a question or two. I probably the audience has some questions as well. I want to make sure that they can talk to one another first.
Can I respond to a few points?
So yeah, that's right. So Marvin, I'm going to start with you to respond, and then open it up to everybody.
Yeah. I'm so happy Professor BeVier was here. She was at the top of my list of people to come and critique me, and she did not disappoint. So I just want to sort of respond to a few points. At one point, she said that the First Amendment's goal is to protect liberty, and the effect is to promote dissemination. And then I'm proposing a revolution. And I think the reason why. Yeah, I think so. Yeah, that's right. I'm admitting. I'm admitting this. And the reason why I think we need some sort of revolution, or at least to rethink the doctrine, is for the reasons Yochai Benkler gave. And really, if you think of where we are with First Amendment doctrine, we look at examples like Citizens United and the problem of net neutrality being unconstitutional. It doesn't seem as though the effect of protecting liberty is wide dissemination. It seems as though the current doctrine doesn't lead to the conclusions. It doesn't lead to the wide dissemination that we hope. And that's why I think a revolution is necessary. And it's partly because there are new speech mediums all the time, and we've dealt with this over and over through a minor exception here, a minor exception there. And at some point, the exceptions sort of weigh down the entire doctrine, and you wonder what part is the exception and what part is the rule. And we might as well at this point try to rationalize it. So that's my thought on that. On the descriptive argument around traditional public forums, these traditional public forums, these streets and parks have been open time out of mind as public easements. I always understood that differently as the case of Hague v. CIO sort of introducing the doctrine in the 30s of traditional public forum doctrine, and earlier cases going in an opposite direction. So to me it seemed, so I guess my notion is that it's not a public easement, and that both Marsh and traditional public forum doctrine do in fact point to a broader principle. That only points to one notion, which is generally when people agree with the case, they think it's a broad case that should apply broadly. And when they disagree with the case, it's narrow, and there are these narrow facts, they try to limit it. And I think you and I come at it from a very different point of view. I think of the cases as broad, and I found evidence for why I think they're broad. And then just a few minor points on the property rights. I love property rights. I do think that I love property rights. I also don't have a very high opinion.
Fooled me about that.
I also don't have a very high opinion of governments. And often when we're talking about First Amendment cases, it's not just, we don't have to believe that the government is flawless, but we do have, but there are some competencies that government has that judges don't have. A lot of times when these decisions are made, it's the judge asked to strike down the communications law, the judge asked to strike down some law enacted by Congress, by some other legislature, and this judge also is not flawless and wise. They lack technical expertise, they lack fact-gathering expertise that Congress has. And I think I said in a recent blog post that it's almost embarrassing defending one institution or another. Congress has a 90% approval rating, full of gridlock, is driving our debt. We've seen Congress fail over and over. The Supreme Court has decided cases like Citizens United and Bush v. Gore. So it's hard to defend either of them. But it does seem as though we're looking at all these imperfect alternatives. In some of these decisions, the legislature has just as much claim as the judiciary.
Are you saying that, or you want me to respond? You don't want me to respond because that's not my turn.
Yeah,
I think whatever would make for a good conversation, because there are ways in which the things I've focused on, not in this presentation, but my writing, are a partial response, so maybe it would be useful for me to suggest a few ways in which what I see what you've done diverges from what I've done, and ask you perhaps to see whether that resolves some of the tensions you have. Would that be a useful?
I'd like to hear that first.
He teaches property.
So yes, I do teach property, and I teach it as a first-year introduction to how states regulate markets, which is what property law is, the basic regulatory framework. But that's actually not where I was going. I think what you try to do, which is to create a foundational claim about the relationship between spaces, including in material space, relative to traditional property. Relative to, for example, what I have been trying to do, which is to say there are problems of communications now, and the relevant universe of cases are the cases in communications, such that Turner Broadcasting and Denver Area Educational Telecommunications District, and Sable about obscenity, and Red Line then becomes part of that, suggests a narrower gauge assault and a narrower gauge set of implications. And the question then becomes, if you want to make an analogy to property law, are we really talking about public accommodations law as opposed to general private law? Because even in physical spaces of property, we have public accommodations, places that are generally open for business and therefore affected with a public interest, and therefore we generally are willing to accept in the context of property law, not in the context of First Amendment law, property law and equality, 14th Amendment, etc., the extent to which we're willing to constrain the property owner's rights because they're a public accommodation. And the question, I'm sorry.
No, go ahead.
So the constraint here is the particular. So first of all, my interpretations are generally negative liberty versions of claims about are claims about the First Amendment constraining the government's ability to implement structural regulations and market structuring regulations for carriage systems, which is to say, for platforms, which is to say, common carriage, must carry rules, public education, governmental and commercial access on cable, network affiliate relationships, ownership restrictions. We have this set of platforms of speech that are privately owned, and we have very rich experience with government essentially trying to keep those platforms open within the constraints of not actually nationalizing. And that's the universe of conversation that's relevant. And the tension that I see, particularly coming out of the arguments that Larry Tribe was very successful in making in the mid-90s and since then, of treating the carriage of bits as speech equivalent to being forced to stand and pledge allegiance or being forced to carry something on the front page. And that's where I think the analogy ought to, first of all, logically breaks down, functionally in terms of the shape of the public sphere ought to break down, and it's not that big of a departure. It's just a question of where you put which platforms in that framework. If you think of bit carriage for net neutrality and open access, of App Store as a general clearinghouse for applications of all sorts, to what extent they fall within that framework of common carrier-like and extended carriage frameworks, the tension between First Amendment and property is not quite as extreme, and the implications for most of the spaces we care about is probably quite substantial, if not get most of everything.
You may be right that the tension is not as extreme with the kinds of networks and things that you're talking about, and I certainly agree that there are, and I think that was a very interesting part of Marvin's paper, which is just to notice that you can describe the regulations of the telegraph and telephone and the nice postal rates for newspapers as having substantial First Amendment implication. And I understand what you're saying there. What would be interesting to me is if the Supreme Court, if those things had ever been challenged, and if the Supreme Court had said, yeah, because in fact the Supreme Court had said, you know, this is, you're right, we have these different things going on here, and we're making opportunities available for speech, and we're letting the government do this, and we are providing subsidies, and we take your money and give it to you so that you can have access to telephone, right? So, and the court certainly hasn't spoken to that. So if you want to say there's a lot of law out there that enhances the amount of speech that is on both in virtual space, in particular in virtual space, that hasn't been successfully challenged, and that in fact nobody's really thought of in real First Amendment terms explicitly, so that they haven't dealt with your argument as a First Amendment matter, then you might be right as a descriptive matter with respect to the doctrine. But the fact that there's a lot of law out there that has been permitted to happen, I don't know where to put that. I think it's completely right that it's as important what the government may do as what the government may not do. But to a certain extent, when you're talking about increasing the government's power over spaces of speech, which you are doing, okay, and you're talking about explicitly increasing the government's power to do that, and explicitly changing First Amendment law to achieve that, then it seems to me that what you need more support, as far as I'm concerned, to persuade me that what has happened so far has been not only permissible, but is actually courts with a particular view of the Constitution. So I think that part of the problem is that when it comes to speech or speech spaces, even virtual world, even in net neutrality, I just don't trust these guys. I'm sorry, I just don't, because I think you have this idea that you project that everyone who's going to want speech to have speech is going to be well served by net neutrality. Well, there are people that say that's not going to happen. In fact, because of technology changes, which have taken place so rapidly, every time we have something, we think, oh, this is new, this is wonderful, and then something else comes along. So, and part of the dynamics of the net, I mean, I don't, my understanding of it, it's not as good as either of yours, of the way the net has been regulated and has developed since it became commercially available, is that it hasn't been less speech, it hasn't been fewer opportunities for speech, it hasn't been, I mean, we talk about everybody having, all you need to do is, if you have a computer, or you have an iPad, or you have an iPhone, or you have any phone at all, or you go to the library, and you can get access to the net, and you can put something out there that everybody sees. Right?
So I mean, to the extent that history of the internet shows that things have changed, people have been able to speak more and more abundantly. During that history, there was a lot of regulation that the government imposed, especially in the early days of the internet, such as common carrier for the phone lines over which the internet ran. One of my thoughts while you're speaking about property rights and how property rights should at times trump speech rights. When I think of net neutrality, that was a rule designed to change the default property rights of the cable companies, make them not be able to exclude applications. But the cable companies themselves get the benefit of a rule that lets them attach to utility poles across the country. That takes away the right of utility companies to say you can't attach it. And so the question, I guess, is would they have a free speech right to say you're attaching these poles to the cable company on the basis of free speech concerns to promote speech to all Americans? Therefore, that goes too far. One, it's a speech-based consideration. Two, it burdens the property rights of utility poles. And how far could you go? And I think the dividing line would have to be a speech principle, not a property principle. You have to decide how far you can go.
A speech principle that would say?
A speech principle that would say, well, the utility pole company, it doesn't really threaten freedom of speech to force utility pole. It doesn't really threaten censorship or viewpoint discrimination. Some of the other things that we really care about to force the utility company to let their property be available to cable companies. And I also think that same principle would apply when it comes to forcing cable companies to open up their property applications and blah.
I sort of think they're different, but it seems to me that utility poles, you could, if you wanted to say that you couldn't do that, it wouldn't necessarily be a First Amendment argument. It would of property rights, right? You're taking my property, right? And it's for what, a public use, and you haven't paid me. You're just, and somehow, you know, you sort of look at the way that happened. Well, it happened because of a political, right? Because the cable companies persuaded Congress that, you know, this is a big new thing, you've got to do it because your constituents all want it, and you've got to get and the must-carry rules are quite similar, aren't they?
Yeah,
So,
this is where you're asking for a revolution in the law, right? On
yeah.
the property side.
well,
And I'm
yes.
skeptical of broad revolutions.
Yeah. It's not. It's actually, you know, there is the Fifth Amendment.
I know.
Although there is, where the baseline is in that story is a complicated one, because there's no inherent reason why the utilities couldn't say, you are forcing us to transmit this video crap people don't read anymore, which is what we care about.
Right.
And that has exactly the same shape of you're forcing us to carry these bits as opposed to those bits. We're not associated with them because everybody knows we have to carry them under law, so it's not about endorsement. The scarcity argument is extremely weak, and at most might suggest internal accommodations for network management under conditions of some, but essentially the dedicating some portion of the wavelength to run over the coaxial cable, which is really all that's required of the broadband carriers, is not fundamentally different than using some portions of the utility in one form or another. It's just about carriage of somebody else's bits over either an enclosed or non-enclosed medium.
Isn't broadband, isn't that scarce? I mean, isn't the fight over who gets to be on broadband, and that's the reason am I wrong?
I mean, there's scarce bandwidth, but the scarcity argument hasn't been made.
But the scarce bandwidth could be cured to the next.
So there are several things. One has to do with spectrum and wireless communications. The other, with regard to net neutrality, has to do with just whether or not you control what goes over your own cable, for which the capacity constraints are not a real source. I mean, they might be waived, but they're not a real source. We're talking about a bandwidth that captures a tiny proportion of the total capacity of a coaxial cable, a fraction. So in that regard, the core drive back, and you saw this, I think, in Denver area educational organizations. This was a case where the Supreme Court split about 7 ways out of the possible 9, precisely because it raised this tension. It was about whether or not Congress could remove from otherwise required access for either commercial or public educational and governmental channels, where they're required, where the cable operators are required as a condition of the franchise to carry these open channels, but they can exclude from that requirement non-obscene, yucky stuff. And non-obscene, yucky stuff in general the government can't regulate, and the question is, can the government keep non-obscene, yucky stuff off by just saying you don't have to carry it if you don't want to on channels that otherwise you do have to carry. So it really sets things up in the sense that you're already accepting that it's that you can undermine the property rights by saying you have to carry. But then you've got a content-based discrimination of stuff that you can't regulate directly. So obviously it got complicated, and you've got a very strong property rights-based wing that says the whole thing stinks. You can't let the government force any channels to be carried. Then there's it's content discrimination that they can't do, and they just do it by the back door. And then there's Justice Breyer said, you're a little right here, you're a little right there, and not too much of this, not too much of that. And I'm sorry, that was not a kind way of putting it. But it's hard. It's this tension that's hard, and it's this tension that gets replicated. And when I talk about ideological drift, I think one of the things that we see is that this core commitment to property rights paints the practical implications for speech. And I know that you're worried about the government, but I think we exist in a country, in a cultural, social context where there are different, highly imperfect and potentially repressive loci of power. Verizon or Comcast are not my representative for what the ideal viewpoint is, and yet they exercise real power over my speech capability. The government is not exactly the place where I would repose the most trust, and yet they have control over my speech and spaces. And the effort is to try to find some context in which you use the power of each to create spaces in which we can all speak. Sometimes limiting this one, sometimes limiting that.
That sounds extremely lovely. I truly...
There's a but after that.
Yes, there is a but, because I just don't know how you get there from any place on this planet. So that's my problem. And I don't know how you're going to get there without having the government say, you have to run that speech whether you like it or not. And we get to say you have to run it because there isn't enough of that speech out there. We know how much is enough. So you do what we say, and you do what we say, because why? We're the government, and we're here to help you. And we have less power than Verizon. I mean, Verizon has competitors. The government, as far as I know, unfortunately, doesn't. So,
I'd say untrue about both of those.
really? At Verizon, it seems to me to be. I mean, they seem to be.
I mean, there's been 100 years of common carrier regulation for the phone system.
That's right.
And we've survived. And
So can we talk about that? Because doesn't it seem, I mean, when I was reading the paper, I thought, yeah, this is very interesting, and I can see where it's going. But then, you know, common carrier regulation is, okay, this is actually the question that the moderator raised when you first asked about self-consciousness, right? I think it's important to stress this because when I think about common carrier regulation and rate regulation, I think of those as economic, sort of standard economic. And they have to do with, it's the same as you have to have your transportation overall. So common carrier regulation is, to my mind, and I could be wrong about this, I mean, I might have to completely think it is not, it's because it's not thought about as a regulation of speech. It's not conceived of as an opportunity so that we can get everybody to have an opportunity to speak. It's economic, it's regulation that is in a different sphere. Now, maybe we just think about them all the same economic regulations. I don't know.
So in your, just a clarification question. So in your framework, if the FCC were to turn around and say, look, we've looked at the last 10 years, we've looked at the actual structure of services, we need to reclassify broadband as combining two separate services, common carriage of bits, and some content on top. And then the common carriage itself, we just regulate it as common carriage. We don't tell you what to carry, we just tell you you can't discriminate among bits in your common carriage. That would not offend your conception of the relationship between First Amendment and property.
You mean
If I could add another question. What if that same rule, the common carrier rule, applies to, say, the cable system? The cable companies have to carry any channel that pays a certain rate as a common carrier.
So then all they're doing is regulating the rates. They're saying at these rates you have to carry everything. Is that what you mean?
Well, first, let's
just the simple question. If you offer, I'll try not to lie and cover things up. Just this guy. Imagine that the facts were such that the rule would basically say if you're carrying broadband, which is to say bits move from place to place according to what the end users decide they want to send and what they want to receive. Nobody programs in the middle. That service is common carriage. No, it's not. Let's imagine that at the moment it's actually up in the air because there have been a decade's worth of debates on the regulatory side about whether that's a good idea or a bad idea. But the question is from either the property perspective or the First Amendment perspective. If the FCC were to say, we looked at evidence of 10 years, and as an economic matter, we don't think there's enough competition. We think there's a lot of benefit to innovation. Common carriage have that basic service of carrying bits, just common carriage. Just the way it used to be for telephone, now it's over OS.
Well, are you asking me?
Yeah.
I thought you were.
I think we're fascinated by
I know, I'm so weird.
No, you were standing there, you were giving a completely coherent critique of, but then where are the limits?
Well, that's exactly right. I could ask you the same. But so, now I have to tell you that I don't know what my answer to your question would be, because first of all, I confess I don't know enough about the regulatory structure that we're talking about. So, absent that knowledge, I don't know what the background of the campus are. I don't know. I just don't know enough about how it's worked. That's one thing. So without that knowledge, that the detailed knowledge about it, I think whatever I would have to say would be, I'd be sort of stuck in my position. I have no idea whether I actually doing. But secondly, I know what my inclination would be to say, well, I'd like to look at the studies of the SEC, and I'd like to see arguments about the regulatory frameworks and so forth. So I'd like to see the case made that what we have now is working. To give, I'd also like some criteria about how much diversity is enough, and some criteria about how much of a speech space is enough. I mean, we've sort of assumed that, oh, that's easy, but I don't think it is easy.
So I'm sorry to do this, but I would love, speaking of opening up to a broader diversity of viewpoint, I think people here would probably love to get a chance to ask some questions. So I don't want to cut anybody off, but is that
Yes.
okay with you guys?
Yes.
Okay. And as people queue up, I just want to ask Professor Benkler a clarification question. But I ask people queue up. So I take Marvin's point to be, look, if the government wants to pass net neutrality rules, that's fine. That's not inconsistent with the First Amendment. Is your view that that's not only true, but also that really they need to, they have to, they should, right? And so, which is your view personally, and sort of how do you defend that going beyond what sort of Marvin sees?
I actually thought that you flipped our position.
Okay, well then
He's the one who would, under this interpretation, suggest that at least at the legislative level, there's a First Amendment implementing role that the legislature play. That would include passing net neutrality. Is that fair or unfair?
I know we could look at it as though congressmen take a pledge to follow the Constitution, and congressmen could say to follow the Constitution and further the First Amendment, I believe it's my role to pass net neutrality. I don't argue that that's judicially enforceable necessarily, but I argue that a member of Congress could believe they're playing their constitutional role.
It's their duty to.
Yes.
It's their duty.
And my claim has been that we have extensive doctrine and communications law to support the proposition that when government intervenes in market structure type regulation to achieve greater competition, to constrain leveraging the market power, a variety of other things, with the purpose of achieving First Amendment goals, that it is free to do so under the First Amendment, not constrained by this particular branch of argument that is the Lochner version of the First Amendment.
Okay, so I flipped it, but it is a matter of sort of must, can, can't on net neutrality, right? Do you come down to view?
Yeah. There are some people who would argue, and they're currently on faculties, that I should go even farther and say that judges would require net neutrality. And I don't go quite that far.
Okay, so there's even a further point.
Yeah.
All right, well, that's what I wanted to find out. So maybe we can start with you, Richard, and then go over.
Yeah, Richard, I was kind of nervous when I saw the description of this panel that it was going to be just heavy First Amendment law. But now that you guys have saw that net neutrality and Yochai is talking about bandwidth abundance and stuff, and I know I'm in the right place. So I can answer my question. Net neutrality, to me, is still not a coherent doctrine. And we see this in some of the discussion that still takes place around what the actual facts were in the Comcast case that the FCC ruled on, and that you two guys were witnesses at one of those hearings in Philadelphia. The actual facts were, the reason that Comcast took action, they had customers who were using voice over IP with Vonage, and they had customers who were using BitTorrent to do peer-to-peer file sharing, most of it pirated content. The Vonage users were complaining that their quality of service was degraded, and they blamed Comcast for having nefariously degraded their quality of service so that they could sell, so that Comcast could sell its telephone services. The BitTorrent users complained that Comcast, when Comcast took some action to resolve that problem, they reduced the amount of network resources that the peer-to-peer folks could get access to, and they did it in a particularly crude way. That's not really completely defensible, but I don't want to get into that.
Can I respond already? Is that enough?
No, let me just I'm almost there.
Okay. It's a little off topic.
And the peer-to-peer users said Comcast was nefariously degrading them so they could sell them, video on demand. And so I don't think it was really a case of the user versus the company, and so you get free speech right by imposing regulations on the company, because the problem that we're actually trying to solve was two different groups of users doing very different kinds of things on a network where both groups were conflicting with each other. So the Vonage users had their free speech degraded by the peer-to-peer.
Okay, that's going to have to be Richard's question for Marvin.
Yeah. That is actually an excellent question. So Richard Stallman is my favorite communist. Bolshevik, sorry, which I thought was very kind of him.
Before you became a Google audience.
It's the kindest thing he ever said to me. But it is actually an excellent question, because when it comes to free speech in the 21st century on these digital platforms, you often have conflicting speech rights. And you could simply say, as a matter of First Amendment doctrine, that the judge the judge reviewing the decision, reviewing the Comcast decision, would choose one speech right over another and say, this is the preferred speech right. Government can't intervene and change the default speech right. But because we have conflicting speech rights, I think that's actually an argument in favor of government being allowed to sort of balance and structure the speech space or the engagement market structure. That's my take.
And I think in general, in this regard, it is a First Amendment panel as opposed to a neutrality panel, because the basic question is, when the FCC encounters such behavior, what leeway does it have? And under what constitutional or legal framework it needs to be reviewed? Is this an administrative action that needs to be rational or needs to be more than that? Is this evidence or that evidence? Or is this a violation of the free speech rights of Comcast, in which case the courts play a different and more aggressive role? And the conversation we're having is that this is the kind of thing that's complex, that a regulator ought to be able to deal with, subject to supervision to avoid regulatory abuse, but not the kind of conflict that courts need to say, this is like government censorship, we need to be extra special here.
So, Ron and then Barbara, and then you have another response.
I don't want to take it off topic, but I think I'd use an example of whether or not we would permit common carriers to say, we won't allow you to transmit based on your race. And I think all of us would just immediately find that incredibly repulsive, but to use that as an example as to absolutely why we would want to allow government regulation that mandates certain things be allowed to be carried over the phone system or the cable tower. It's just a little bit disingenuous to say that we have no room for regulating because it's private. And of course, we all require a lot of regulation. The last thing I would argue is we don't have government spaces here that are equivalent to parks. We want to set up a government phone system, a telecommunication system to allow for this when so much speech goes over that. And I would argue that in a certain degree, when we're seeing private carriers take on a government function, and to me this is quite a government function, somewhere in here we have to make room for this. It's completely appropriate that we mandate public spaces on
You're speaking to the choir.
Okay, yeah, all right, so that's from Barbara.
I think it's a question.
Well, it's not a question, it's a statement of his position, so I think it's.
So Barbara, I'm going to give you the last question here, and then we're actually going to go right into the next channel because of some of the speakers have a conflict later in the day. But please, if you need a couple minutes, after Barbara's question and answer, you can filter out. But I'm going to start right after the next panel in just a few minutes.
First, thanks for the discussion. I thought it was really interesting to see, for example, Yochai versus Marvin's position, and that made me think Mike was something that yes, that whether Marvin might need to be more nuanced in looking at different types of regulations. So it seems to me, listening to you, that you have relatively little problems with common area type regulation. And because a lot of the concerns you describe, how would the government make these types of judgments, these concerns don't really occur in this context because the government doesn't actually make the judgment. It just says whatever happens on the stage needs to happen without interference by the network provider or the person who provides the common area service. And then, but once you move to spaces where you say the government needs to make enough speech spaces available, there you have a problem because how do you decide how much is enough and how much diversity is there? So the first question would be, is that actually, would your concerns split along these lines? And then if yes, I would just add that network neutrality is commonly conceived as being the common area types, and so your concerns about the government deciding, who gets to speak wouldn't actually apply because the only thing network neutrality would say is the network provider can't interfere with the speech by users that happen. And then, the question, the equivalent question to Marvin would be, do you actually draw the line? Are you more concerned about being enough and
I need on the first side.
Your whole paper is about sufficiency, right? So.
Yeah. So the rules that I endorse tend to be rules similar to the one you described, which is opening up spaces non-discriminately to all speakers, or to a certain class of speakers, like to all broadcasters, sort of without inviting government in to make nuanced content discriminations after setting the initial framework. So I'm in agreement with that. And in terms of sufficiency, how do we determine what's sufficient? I discussed that a little bit. How do we know we have enough spaces for speech? I think that's a political question that we would debate. The government, the FCC, Congress, also in dialogue with the government, with the judiciary, sort of figure out that it's a political question, that it changes, and that it's not something that can be, just as other questions are determined through politics. His example, Yochai Benkler's example being Congress v. Hardwick changing over time. I think it's a political question that we can determine and we debate it. What's sufficient? Is it sufficient if we have access only to net neutrality on the wireline internet and not on the wireless internet? Is it sufficient if we have net, which was a distinction made by the FCC? Is it sufficient if we have on the wireline wireless internet but not in the app store? I think that's a political debate that's worth having, subject to some judicial rule against discrimination and very intrusive regulation beyond setting and opening the platforms.
Last word?
Go ahead.
No, your last word.
I don't think I should give the last word. You should have the last word.
Can I say
Very
it?
nice.
Last word, yeah. Thank you so much for coming.
Yeah, thank you. This was really amazing. Thank you.